Good day, ladies and gentlemen. Welcome to Criminal Law TV. I'm your host, Ken Lammers. And today, what we're going to talk about are the changes that the Virginia General Assembly has made in the law, which will go into effect on July 1st, 2011. Some of which have already gone into effect, but most of them July 1st. And so, let's get to it.
The number you have reached, 911, has been changed to a non-published number.
Hi, I'm Ken Lammers, and welcome back to Criminal Law TV. I haven't done one of these in a while, and what this one's going to be about, though, is the changes in the law in Virginia that are going to go into effect on the 1st of July, 2011. Now, these are mine. I went through and combed the statutes myself and got these, and so I may have missed something. If there's something that you specifically are more interested in, go look it up yourself to make sure that my interpretation is right. But here's my interpretation of the changes and the ones that I caught that are changes to the criminal law. On HB 1479, that changes 19.2-54 about search warrants, and it makes an affidavit available 15 days after the warrant has been issued or immediately after the warrant has been executed. HB 1487, that is venue for sex crimes, and it says that if the crime occurs in one county but the person to whom the crime is done is transferred through several counties or cities in Virginia, whatever polity, that if the Commonwealth Attorney in the county where the crime actually occurred agrees, the crime can be prosecuted in any county through which the victim was transferred. And that's changed to 18.2-359. HB 1650 and SB 782, this is a change to 19.2-71 and 19.2-72. And basically what this is doing is saying that a magistrate cannot issue a felony warrant to a citizen complainant unless the Commonwealth Attorney has approved it or a member of a pertinent law enforcement agency with jurisdiction has approved it. So last year they took like a half step and said that the magistrates had to consult with the Commonwealth attorneys or the law enforcement agencies, which was kind of, they needed to either make a full step or pull back and let the magistrates do it all on their own. They decided finally to make it a full step. HB 1713 changes 19.2-120, and if a person is arrested for obstruction of justice for trying to tamper with a witness, threaten a witness, he is presumed not to be able to get bond. HB 1909, sealing of a search warrant. 19.2-54 is changed so that a search warrant and the affidavit can be sealed by a court upon good cause shown by the Commonwealth in an ex parte hearing for a specific amount of time. The order sealing the warrant can also be sealed by that same order. HB 2060, capias bond, and that changes 19.2-130.1. It says a magistrate must set a bond as ordered by the court as part of the capias, but the magistrate can set more restrictive terms than the judge had required. It just has to go at least as restrictive as the judge. And SB 1162 changes 19.2-81 to give special agents of the Alcohol Beverage Control powers of arrest as a police officer. So that's really now there are also some changes on appellate issues, but I didn't really go through those. But those are the ones that stuck out to me as things that people who practice criminal law or enforce criminal law would like to know. Okay, so the substantive changes are going to be broken into several categories, just like I do when I brief case law changes. First is going to be violent crimes. HB 1516 changes 18.2-57 and makes an ABC agent, alcohol beverage control agent, a law enforcement officer as far as the assault and battery statute is concerned, and so therefore it gets the mandatory minimum 6 months punishment and is a felony to attack an ABC agent. Fire marshals. This SB 772 changes 18.2-57 so that assault and battery of a fire marshal with police powers, and I leave it to you to go figure out who does and doesn't have police powers as a fire marshal, but assault and battery on that fire marshal is an assault and battery on a law enforcement officer carrying the 6-month mandatory minimum sentence, and it's a felony. HB 1690. Assault and battery on a healthcare worker, and this again changes 18.2-57, the assault and battery statute, and it makes attacking a healthcare worker engaged in an emergency aid at a medical facility is a class 1 misdemeanor with 2 days mandatory minimum time in jail. So I mean, any assault and battery is at least a class 1 misdemeanor. Basically the change here is that if they assault an emergency care worker, they get 2 days mandatory minimum. HB 1898. Now this changes 18.2-48, the abduction statute. Anyone abducting a person for production of child porn has committed a class 2 felony, 20 to life. It also changes 18.2-356, and it's taking money from any person to engage in forced labor services, concubinage, prostitution, or the manufacture of any obscene materials is a class 4 felony, and or also child pornography is a class 4 felony. So that would be up to 10 years, 2 to 10 years. HB 2063. Now there's a whole bunch of changes here to protective orders. And 16.1-228 expands family abuse to include threats that put a person in reasonable apprehension of death and sexual assault, as well as just bodily injury. And it adds a bunch of new language, said that such acts includes forceful detention, stalking, criminal sexual assault, and any other criminal offense that results in bodily injury or places one in reasonable apprehension of death, sexual assault, or bodily injury. I would have thought that most of that was probably covered already, but it has broadened. I think that the stalking part is the most pertinent because it will allow to stop guys from stalking women. Family protector orders are to prohibit family abuse or, and this is the added language, criminal offenses which injure a person or property. Now this has changed for both 16.1-253.1, which is preliminary hearings, 16.1-253.4, which is emergency protective orders, and 16.1-279.1, which is a full-on protective order. So all protective orders are covered by this language, changes in all of them. 18.2-60.4 is changed so that violating a protective order is, for the first offense, a class 1 misdemeanor. The second within 5 years, and one of the two is based upon a threat or act of violence, is a class 1 misdemeanor with 60 days mandatory minimum in jail. A third within 20 years, and one of the three is based upon an act or threat of violence, is a class 6 felony with a mandatory minimum of 6 months in jail. Assault and battery on a person in violation of a protective order is now a class 6 felony. For those of you who don't know, class 6 felonies carry up to a maximum of 5 years in prison. Sneaking into home of a protected person is a class 6 felony. Entering the home of the protected person and waiting until the protected person gets home is a class 6 felony. And no matter what sentence imposed by the judge cannot suspend the entire sentence. So, any violations of a protective order from this point on, the judge cannot suspend the entire sentence. They can sentence somebody to 12 months, but they have to leave, and they can only suspend, 364 days. That's the 365th day, the guy's got to serve. He's got to serve some time. Okay, 19.2-81.3 C is changed so that if a law enforcement officer has probable cause to believe that a violation of a protective order involves physical aggressions, he shall arrest the predominant physical aggressor, absent special circumstances. Special circumstances are, as best as I can tell, not laid out, so it will be in the officer's discretion. Determining the predominant physical aggressor is laid out, what they're supposed to consider. First is, who was the first aggressor? Second is, protection and health and safety of the person whom the protective order was issued to, and their family and household members. The third is prior acts of violence, force, or threat by the person against whom the protective order was taken out. Fourth is the relative severity of the injuries inflicted on the persons in the incident. The fifth is whether the injuries were inflicted in self-defense. The sixth is witness statements. And the seventh is other observations. So officers are supposed to take those into consideration when they decide who the predominant physical aggressor is to arrest them in a violation of the protective order. 19.2-120B11 is changed. So there's a presumption against bond for a second or subsequent protection order violation. 19.2-152.8B is changed. So that protective orders are to prohibit acts of violence, force, or threat, or criminal offenses resulting in injury to a person or property. They are broadened to be issued for these reasons on probable cause. And this is for 19.2-152.8B, which is an emergency protective order. This is for 19.2-152.9, which is a preliminary protective order, and it is for 19.2-152.10, the full-on protective order. So they've been broadened to be covered to anybody who's subjected to an act of violence, force, or threat. So that's a broadening of that. I think it changes those from being, it makes it broader. 19.2-152.8D is changed so that if a protective order is if a protected person is physically or mentally incapable of filing a petition for their own protective order, an officer may request a 3-day extension of the emergency protective order. So, emergency protective orders last 3 days. After that, the person who asked for it has to be in court to get the preliminary, and after that, they have to be in court for the full-on protective order. If they're in such a mental state that they cannot themselves, mental or physical states that they cannot themselves, go in and ask for the extension of the emergency protective order, an officer can do so for them. Notification of a protective order. Now this is in HB 2089, and it changes 16.1-264A1 so that any person who's subject to an emergency protective order and is personally served with a protective order if the law enforcement officer gives them a notification of issuance of the order on paper that's supposed to be approved by the Executive Secretary of the Supreme Court of Virginia. So it has to have all the information and requirements on that form that's turned over to the person. The officer that makes that service has to enter the date and time and everything into the NCIC and make the return to the court. So that's it for the violent crimes section. And our next section is about sex crimes. This will be fairly short. HB 2066 and SB 1185 change 18.2-370.5. So a sex offender cannot enter a school bus or go onto any public or private property which is being used for a school-related or school-sponsored activity. Violation is a Class 6 felony, up to 5 years in prison. SB 1318 again changes 18.2-370.5, so a sex offender can't go on school grounds after after school hours, if the school grounds are being used for a school-related or school-sponsored activity. Again, this is a Class 5 felony. And the final change having to do with sex crimes is HB 1747, which is SB 1260, and that changes 18.2-374.1:1, so that law enforcement agencies can possess child porn for governmental purposes, which I'm sure is relieving a lot of law enforcement officers who are terribly worried about that, I'm sure. Drug crimes. HB 1407 and SB 770, underage drinking. Change the punishment is now a Class 1 misdemeanor with 1 year of loss of license. I think right now it's only 6 months, but 1 year loss of license, fine of $500, and or 50 hours of community service. I think the main big change there, I think, is the 1 year for anyone under 21 who's been drinking and gets 0.02 blood alcohol content when they're pulled over. HB 1496, buying alcohol for minors. This one changes 4.1-306 so that you don't just have to know a person is a minor, you can have reason to know that they're a minor, and just having reason to know that they're a minor, the addition, is enough to get you convicted of a Class 1 misdemeanor. HB 2256, and that's also SB 1150, a change in the pharmacy rules. As you recall, last year they put a whole bunch of rules in for the pharmacists, what they were going to have to do if to sell Schedule II drugs. And this changes 54.1-3420.1. And before a pharmacist gives a Schedule II drug to a person unknown, the pharmacist or the pharmacist agent, that's the main change, they add the pharmacist agent, they must make a copy of a government ID or record the name and address of the recipient. This record must be kept for a month. You'll recall that last year, when the statute was passed into law, they were going to make them keep it for a year. Well, apparently someone didn't like that, so now they only have to keep it for a month. SB 1096, and that changes 54.1-3434, now allows all pharmacies to have access to the prescription monitoring program, the database of all the pills that have been sold and bought throughout Virginia, but does not require them to access it. So, they can play straight and check to see if this guy's bought 6 different prescriptions of OxyContin in the last month, or they can just ignore it. The big thing, of course, the law that was rushed into place immediately was the synthetic cannabinoid bath salts law. They 18.2-248.1:1, possession of these items is a Class 1 misdemeanor. Distribution is a Class 6 felony. Distribution as an accommodation is a Class 1 misdemeanor. And distribution to an inmate is whether state or local, is a Class 4 felony. Manufacture is punished by 5 to 40 years in prison and up to a $10,000 fine. 18.2-255.1, distributing, printing materials, advertising, or explaining the use of synthetic cannabinoids or bath salts, bath salts, is a Class 1 misdemeanor. 18.2-55 is changed so that distribution to someone under 18 or causing someone under the age of 18 to be involved in distribution is punished by 10 to 50 years incarceration and 2 years mandatory minimum. 18.2-255.2, if you distribute or possess to distribute within a 1,000 feet of a public school or a place dealing with mental health, mental retardation, or substance abuse services, it's a crime, both punished by up to 5 years in prison and a $100,000 fine. Second violation of the same thing carries a maximum carries the same maximum punishment, but has a mandatory minimum of 1 year incarceration. 18.2-258. Any owner, lessor, agent, or lessor, manager, chief, executive officer, operator, or tenant who knowingly permits, establishes, keeps, or maintains a place where users congregate to use synthetic cannabinoids and all, is guilty of a Class 1 misdemeanor, and second or subsequent offense is a Class 6 felony. 18.2-258.02. If a house is reinforced so that it can be used, manufacture, or store these drugs, it's a Class 5 felony. 18.2-308.4. Possession of a firearm while distributing or in possession with intent to distribute these kind of drugs is has a mandatory minimum 5 years of incarceration. There's also the maximum, so you get the max. 18.2-474.1. Delivery, conspiracy delivery to an inmate is a Class 5 felony. 53.1-203. Possession by an inmate is a Class 5 felony. These laws all went into effect on the 23rd of March 2011. It was considered emergency legislation. So now we're at theft and property crimes. The only real change that I think is pertinent for those of us that have problems with wires and copper and aluminum and all this stuff being stolen, HB 2050 changes 59.1-126B so that anyone who buys secondhand metal has to pay by check if it's more than $1,000. I can't recall the last time we had somebody go to the scrap metal place and get more than $1,000, but I'm sure it happens. So if it's ever over $1,000, they have to be paid by check. Weapons crimes. HB 1411, reckless handling of a firearm while hunting. Using a firearm while hunting recklessly is a Class 1 misdemeanor, and the judge can revoke the violator's ability to hunt or trap with a firearm for 1 to 5 years. Hunting with a firearm while revoked is a Class 1 misdemeanor, and the judge can revoke the violator's ability to hunt or trap for 1 year to life. And some of those of you who live in the city, that's probably not a big thing. Around here, that's almost a death penalty. SB 754 and HB 1779, they change 18.2-308.1:4, changes a ban on those under a protective order, preliminary protective order for protection of a child, which is 16.1-253, to only those under a preliminary protective order for neglect or abuse of a child. SB 757, about pneumatic guns and private property. Pneumatic guns and air gun, folks. BB guns, or shoot darts, whatever, but powered by air, not by explosion. And it changes 15.2-915.4. The locality cannot prohibit the firing of a pneumatic gun on private property if it is allowed by the landholder and reasonable care is taken to keep the projectile from going onto other property. So a person can fire air guns all day long as they make efforts to make sure it doesn't go on other property. The next section is about motor vehicle law changes, and we'll start with HB 1981, and this changes 46.2-883, and it says that if a motorcycle, moped, or bicycle is trying to make a left-hand turn, and 2 cycles go by, and the light doesn't switch for him, or he sits there for 2 minutes without the light turning for him, he can make that left-hand turn. As long as he checks to make sure there's no traffic he's going to hit or such things like that. Obviously meant to deal with the fact that often a bike won't trigger the mechanism meant to make the turn, make the light change so that a car can turn. HB 2362, restricted driver's license while in jail. This changes 18.2-271.1. And a restricted driver's license is allowed for trips to and from the jail to serve weekend sentences or sentences on non-consecutive days. So if they are serving either the weekend or for some reason it's set up so they're serving Tuesdays and Wednesdays or whatever, they can have a restricted license, go to jail, park there, get their car back when they get out, and drive home. HB 2374 changes 46.2-100 and makes a moped a motorcycle whenever it travels over 35 miles per hour. HB 2391 changes 46.2-398. This changes the law so that if a person has a valid driver's license from another state, but the judge suspends him in Virginia, the judge cannot take the out-of-state driver's license. He's just suspended and can't drive in Virginia. He's got to deal with Kentucky or North Carolina or Maryland or whatever on his own. So the judge can't take his license. HB 2423, this is warrants for those who are DUI or DUID on a watercraft, changes 19.2-81 so that an officer can arrest for probable cause for a DUI on a watercraft and transfer custody to another officer, and that other officer can take him to the magistrate and get a warrant sworn out based on the statements of the first officer, the initial arresting officer. HB 2420, TV in a motor vehicle. This changes 46.2-1077. No TV to be up front where it can be seen by the driver while he's driving. There are exceptions. There's a number of exceptions already in the law, and there's some new ones they put in. If it is a vehicle information display, if it's a TV used to see other occupants of the vehicle, I guess if you're going to look at little Bob and Joey and Mary in the back, I guess you can have a TV for that. Not that I think that'd be any less distracting, but you can have it under the exception. If it's used for safety or traffic engineering information, so if it's giving you what you would normally get out of your rear view mirror, you've got a TV camera in the back doing the same thing, I guess it's valid. And if it has an interlock which stops it while the vehicle is being driven. HB 2485, reckless driving on government property. It changes 46.2-864 so that reckless driving can happen on government property which is open to the public. Now we get the rest, everything else section. HB 1442 is changed so that 18.2-197.1, if anybody removes an electronic transmitter from a dog, falcon, hawk, or owl to keep the owner from finding it, that's a Class 1 misdemeanor. 18.2-136 says that if an owner goes onto a prohibited land to retrieve a dog, falcon, hawk, or owl, which has strayed during hunting, it's a Class 4 misdemeanor for the animal owner if he does not identify himself to the landowner or landowner's agent upon request. You can go on to another person's property, cannot take a weapon with you, but you can go on another person's property to retrieve your animal. HB 1461, trespassing. 18.2-119 allows an agent of the owner, lessee, or custodian to bar somebody from the property and place no trespassing signs. I think this is reaction to a case which was, I think, 2 years ago now. HB 1541, which is SB 1026, changes 3.2-6503.1 and makes it a Class 4 misdemeanor for agricultural animals to be mistreated. Obviously, mistreatment of things such as chickens and that is going to probably not fit what mistreatment of Fido would be. HB 1584 changes 18.2-325 so that overpaying for access to an internet site where one can win money is illegal. Overpaying for another thing, which we gamble to get money back, is illegal. Paying for access to an internet site or for other things which are incidental to the chance to win money is illegal. And they change it so it's no longer required that items be redeemed where they are bought for it to be illegal gambling. I didn't really get this at first. Somebody made a comment on the blog which made sense. This is something where they're probably trying to shut down internet cafes, which you pay $1,000 walking in the door, or $100 walking in the door, or something like that, and you access the internet to play whatever games and stuff and get points, credits, ducats, whatever, and can get money back at the end. So you'd be paying for internet access at an incredibly high level, just as a cover to gamble. HB 1605, fraudulent medical records. This changes 18.2-260.1 so that falsifying a medical record with intent to defraud is a Class 1 misdemeanor. HB 1777 changes 18.2-204.1 so that possession of a false birth certificate is a Class 1 misdemeanor. Creating or transferring a false birth certificate is a Class 6 felony, up to 5 years. Class 1 misdemeanor is up to 12 months. Possessing or transferring a false ID is a Class 1 misdemeanor. Anyone possessing or transferring a birth certificate or ID with the intent to purchase a firearm, a false birth certificate or false ID with intent to purchase a firearm, is guilty of a Class 6 felony. HB 2059, profane and threatening language via video. This changes 18.2-427 so that profane and threatening language received via video or electronic communications, a cell phone or electronic device covered by the statute. So if I send somebody something obnoxious on this iPad, it's covered. So would all the really fancy phones everybody has now, the Androids, the iPhones, whatever. They'll be covered, Windows 7 maybe. They would be covered under this. It's just an expansion for the changes in the technology. And the final one is SB 1067. This changes 19.2-8 so that the prosecution for unauthorized practice of law has its statute of limitations increased from 1 year to 2. So if you're out there practicing law improperly without a license and you think you've almost gotten away with it because it's been a year, well, we got another year to get you. And ladies and gentlemen, that's the laws that have been changed this year for Virginia. I'm putting this out a little bit early because I had some of the interns in our office do the same thing, and I wanted to put this out before I checked theirs, so there was no, so nobody would say I took their stuff or anything, and not that it would, but just to be fair to the kids. And I don't know when I'll next do this. Probably sometime in the near future about case law, but we'll see. I wish you all a good day, and see you next time.